Hello, my name is Dahlia Racine, and I am a Deputy Chief Assistant District Attorney in DeKalb County District Attorney's Office. For those that don't know, DeKalb County is in the metro Atlanta area in the state of Georgia, and we are one of the largest jurisdictions in the state of Georgia. I've had the pleasure of serving as a prosecutor for almost 15 years now, a majority of that time focusing on sex crimes involving both women and children. And so today we want to talk about the prosecution of sexual assault cases. And this may seem elementary, but let's first talk about the training goals. We want to first define sexual assault. Those of you who may be watching may say, we all know what sexual assault is, but let's just get on the same page of a comprehensive definition of what is sexual assault. The next goal that we have is to understand the perspectives involved, the victim's perspective, society's perspective, and most importantly, the prosecutor's perspective when you are trying to prep one of these cases. The other goal that we want to look at is getting your case prepared, both the investigation and trial prep, as well as the impact that these cases have. So let's get started. What is sexual assault? Well, sexual assault is defined as having or attempting to have sexual contact with another individual without consent. Pretty basic, pretty standard stuff. Let's delve into what sexual contact is defined as. It's the intentional touching of another person's clothed or unclothed body with any part of another's body or an object in a sexual manner, or causing another person to touch their own body or another person's body in a sexual manner. So that involves a lot of different types of contact and conduct. Now, what the element that you must prove is a lack of consent. In a sexual assault case or in a sexual interaction case, consent is communication of affirmative, conscious, and freely made decisions by each participant to engage in agreed upon sexual contact. And so when you talk about this broad umbrella, this broad scope of cases that we are defining, there's lots of types of sexual assault offenses. Again, this is terms that we use here in Georgia. In your jurisdiction, they may use a different term, but the terms of the crimes that we have that fall under this umbrella are rape, aggravated sodomy, aggravated sexual battery, and sexual battery. Again, remember the conduct can include those individuals who are clothed or unclothed and being touched in a sexual manner without consent. So let's talk about consent for a second. Consent seems to be one of the most elusive concepts to the defense bar, and sometimes, unfortunately, to our judges too. So when we talk about consent, a really good idea is maybe perhaps to give them this great video that went viral a couple years back called Consent Tea. So let's take a look at that.
If you're still struggling,
just imagine instead of initiating sex, you're making them a cup of tea. You say, hey, would you like a cup of tea? And they go, oh my God, I would love a cup of tea. Thank you. Then you know they want a cup of tea. If you say, hey, would you like a cup of tea? And they're like, I'm not really sure. Then you could make them a cup of tea or not, but be aware they might not drink it. And if they don't drink it, then, and this is the important part, don't make them drink it. Just because you made it doesn't mean you are entitled to watch them drink it. And if they say no thank you, then don't make them tea. At all. Just don't make them tea. Don't make them drink tea. Don't get annoyed at them for not wanting tea. They just don't want tea, okay? They might say, yes, please. That's kind of you. And then when the tea arrives, they actually don't want the tea at all. Sure, that's kind of annoying as you've gone to all the effort of making the tea, but they remain under no obligation to drink the tea. They did want tea, now they don't. Some people change their mind in the time that it takes to boil the kettle, brew the tea, and add the milk. And it's okay for people to change their mind. And you are still not entitled to watch them drink it. And if they're unconscious, don't make them tea. Unconscious people don't want tea. And they can't answer the question, do you want tea? Because they're unconscious. Okay, maybe they were conscious when you asked them if they wanted tea. And they said yes. But in the time it took you to boil the kettle, brew the tea, and add the milk, they are now unconscious. You should just put the tea down. Make sure the unconscious person is safe. And this is the important part again. Don't make them drink the tea. They said yes then, sure, but unconscious people don't want tea. If someone said yes to tea, started drinking it, and then passed out before they'd finished it, don't keep on pouring it down their throat. Take the tea away. Make sure they're safe, because unconscious people don't want tea. Trust me on this. If someone said yes to tea around your house last Saturday, that doesn't mean they want you to make them tea all the time. They don't want you to come around to their place unexpectedly and make them tea and force them to drink it going, but you wanted tea last week. Or to wake up to find you pouring tea down their throat going, but you wanted tea last night. But if you can understand how completely ludicrous it is to force people to have tea when they don't want tea, and you're able to understand when people don't want tea, then how hard is it to understand it when it comes to sex? Whether it's tea or sex, consent is everything. And on that note, I'm going to go make myself a cup of tea.
So you may wonder why we went through that in-depth video as to what consent really looks like. But once you really get involved in these cases and you handle them for a while, you'll see that consent becomes everything, just like the video said. So let's talk about who are the victims of sexual assault. Well, women, men, children can all be victims of sexual assault. But for the purposes of this presentation, what we'll be focusing on are women who are victims. And when you think of a woman who is a victim of a sexual assault, sometimes the perception is, well, who is that woman? And what we have to know as prosecutors is that we will be the standard bearer no matter who that woman is, whether she's a wife, a drug addict, a sister, a convict, a mother, a grandmother, daughter, a virgin, or a prostituted person. Nobody deserves to be sexually assaulted. Now, when we look at who our perpetrators are, we also know that we see the full gamut. Men, other women, juveniles can be those that are responsible for the sexual assault of an adult female, spouses, family members, acquaintances, strangers, pimps, buyers of sex, drug dealers, and religious leaders. And pretty much the list is anyone could be potentially a perpetrator. So why is it so important for us to take the extra step to make sure that our sexual assault case is prepped? Well, quite honestly, these are some of the most important cases to prosecute. This is an extreme violation of a person. And throughout my term as being a prosecutor over the last 15 years, I have been able to try cases that run the gamut from homicides to armed robberies to sexual assault cases. And these happen to be some of the most difficult cases. And you may wonder, well, why? For those of you who haven't tried to handle them. Well, number one, you have to prove a crime occurred. So this is unlike a homicide case where you have a dead body. It's obvious a crime has occurred. And then you have to go the extra step of them proving who. So that makes these sometimes even more challenging than other cases that you may deal with as a prosecutor. What you want to make sure that you're doing is a victim-centered approach when you handle these cases. You want to ensure that the victim's wishes, her safety, and her welfare take priority in all matters and procedures. That's what they deserve. That's what they are owed after what they've been through. Now, most sexual assault victims don't tell. Survivors have cited various reasons for not reporting, and the Maryland Coalition Against Sexual Violence compiled a list. And even if you're dealing with a victim who has reported, understand that these still may be their same concerns, even though they've said something. There's a fear of reprisal. Well, what's going to happen if I tell? They could say it's a personal matter. There may be even association with embarrassment or being ashamed at what happened to them. They reported it to a different official and they were said, well, it's not us, go speak to somebody else. And they may just give up. It's not important enough for some folks to respond to what happened to them. They believe that the police won't do anything to help or that the police couldn't do anything to help. or they don't want to get the offender in trouble with law enforcement. And we'll talk about some of those evaluations of relationship between the perpetrator and the victim later on. They may not want their family to know. I mean, for example, if this is a mother and a father who have since split, and then he comes back and he rapes her, she may not want her children to know that their father is a rapist. So these are the different dynamics that you have to consider. They may not want others to know what happened to them, because once it's reported, it becomes, unfortunately, a public matter. They may think there's not enough proof. They have fear of the justice system. They just don't know how. They say, you know, we may assume, well, it's really simple. Just pick up the phone, call 911. But the reality is that there are a lot more intricacies, because same thing that you heard before. What if you make that first 911 call and they tell you, oh, it's not us, go find somebody else? There could be that as a deterrent. They feel the crime was not serious enough. If, for example, the sexual assault was not a rape, maybe they feel that that offense that happened to them, that violation, that assault, is not serious enough for law enforcement to take seriously. They fear a lack of evidence. That we see, unfortunately, all the time within the media, on TV, the lack of evidence that could possibly be there. And that's another thing we'll address. And they're unsure about the perpetrator's intent. Well, maybe he didn't mean to take it too far. Maybe they didn't mean to do what they did to me. And so then there's some doubt as to whether they should pursue those charges. The other thing that we need to be aware of is society's perception. The unfortunate reality is that we do a lot of victim blaming in our society. Our entire criminal justice system is set up to protect the rights of the offender, which, even though we do not have a perfect criminal justice system, we have one of the best in the world. But what that does is, unfortunately, puts the victim on trial. And oftentimes the defense has a field day with blaming the victim. Not only that, we also know that society's perception is to judge the victim and not the evidence against the defendant a lot of times. You'll hear a lot of things like, well, she asked for it, or she didn't fight back. Well, what was she dressed like? Was she flirting with him? Was she acting like a slut? Was she drunk? Was she walking alone? Well, did she say no? Was she on drugs? We're constantly asking questions that evaluate the victim and not looking at the evidence against the defendant. And that happens all the time, and you have to be aware of it, because that's what's going to happen with your juries as well. So let's get into it. Let's get the case ready. That sexual assault case comes across your desk. And regardless of how your jurisdiction works with them, let's assume that you get that phone call from law enforcement, or it's a file that's several weeks old prior to it landing on your desk. We have to be aware of our own perception as part of our preparation. We have to look in the mirror and know who we are before we pick up one of these cases. We have to know the victim's relationship to the perpetrator. Do we understand the emotional baggage that comes along with this victim reporting? Do we understand the financial commitment that she may have to the offender? Do we understand her fear, her attachment to the offender? Or like the scenario we talked about before, where it's co-parenting. And so before we make judgments on who our victim is, because we have to be aware that we are not doing that, we have to understand the dynamics of their relationship to the perpetrator. And let's be aware of what we are asking our victims in sexual assault cases to do. There are several times when I try one of these cases and you're telling the jury in closing about all your evidence, and we always say, look, don't underestimate what the victim in this case had to do. She had to sit here in front of a room full of strangers. In the room, the man, woman, whomever has sexually assaulted her, and explain it in excruciating detail to all of you. And if you think that's so easy, then everybody go in the back, and first thing you do is discuss your first sexual encounter, whether it was consensual or not, and let them ask you any and every question that they want to, because that's exactly what our victims had to do. So as a prosecutor, be cognizant of what we ask our victims to do on the stand. The trauma-informed approach. So with this approach, especially in sexual assault cases, regardless of what the age of the victim you're dealing with, you want to be cognizant of being trauma-informed. So what is that? Well, it's basically realizing the prevalence of trauma. It's recognizing how trauma affects each individual. And it's responding by putting that knowledge into practice. There's a lot of great online-based trainings that cover this type of information, and it's great for your entire team to be well-versed in this. Those that are going to encounter victims, whether it's from your DA's office, whether it's from your law enforcement offices, whether it's from your service providers, whomever it is that is on the front lines of dealing with your sexual assault cases, it's very important to be trauma-informed. So why the trauma-informed approach? Well, it's ideal in prosecuting these sexual assault cases because, number one, it enhances the victim involvement. Most of the times you will not have a case if you do not have a victim. And so you want to be sure that from the get-go, your victim is treated the best way possible and that they are involved in this case. It also ensures less likelihood of re-traumatizing that victim. It's not easy for that victim to go through the criminal justice process. It's just not. There's no way for us to avoid our victims getting beaten up throughout this process. But we could try to minimize that. We could try to minimize the negative impact that this will have by being sure that we are surrounding them with services, we're surrounding them with communication, and making sure that they are well aware of what this process entails. Also, by being trauma-informed, you build a stronger case. You increase your likelihood of holding the defendants accountable because when you have that good rapport and relationship with your victim and your victim knows that they are being put first in this process, they're naturally going to be more open to you. They're naturally going to provide you with more information, which in essence allows you to build the stronger case. So realizing the prevalence of trauma is going to be very important. And like we said, it's very important that the entire team that you're working with is trained in this area. So we have to recognize how trauma affects the individual. Trauma can be implemented in a person from a one-time event or a series of long-term events. So don't think that just because this event happened one time, maybe it lasted 2 minutes, that victim does not have a right to be traumatized by what occurred to them. And also recognize that each person experiences trauma differently. Don't think that just because you see one victim respond in a certain way that all your victims will. And those nuances and idiosyncrasies you have to be prepared for and be aware of because they can impact your trial. And we will talk about that too. You want to make sure that you are responding by putting this knowledge into practice. You have to respond to your victims in a sensitive, compassionate manner and focus on the victim's needs. Now, does that mean that you never confront them with an inconsistency? Of course not. But they have to know that when everybody else is coming against them, that you're standing up for them. And that's a very important part of dealing with these types of cases. It also helps you to enhance victim involvement. Remember, we discussed those goals initially. Use a victim advocate. If your jurisdiction has one, make sure you are using them properly. As a prosecutor, a victim advocate is like one of your best friends. It is one of the best tools you have to not only make sure you're collecting the best evidence in a case, but also to make you a more effective prosecutor so you have somebody on your team that's able to deal with some of the other elements and issues that can come up with your victim. You want to empower your victim. Allow them to tell you what happened. Don't feed them the narrative. Let them tell you in their own words. And then it's on you as the prosecutor to decipher and figure out what they told you and how that fits into the elements of the crime. Be very transparent about information with the case. Make sure they know about the upcoming court dates. Make sure they understand what those different court dates mean. Understand that they have a right to be there, but if they don't need to be there because they may have a work schedule or something along those lines, just being very transparent in what you need to tell them. And allow them to make decisions in this process. Now, granted, there may not be a lot of decisions they can make because obviously the charging decisions and when a case goes to trial, those are things that are out of their control. But there are certain decisions that they may be able to make, and let's make sure we give them that option to empower them through that process. And be honest, don't oversell it. Never as a prosecutor do you go in and tell your victim that you guarantee a conviction, that you know you're going to win this case, that this guy is going down no matter what. What I always tell my victims is, I don't know what the jury will do. And after going through a lengthy explanation of the options, I sit and I tell them, no matter what happens, what you will know is that I will stand up and fight for you like hell because you deserve it. And that is what you have to tell them without any promises of an assured outcome for this trial. And when you do this, there's less likelihood of re-traumatization. The team working together requires less interviews for the victim. Oftentimes, I'll go to my victim witness advocate who is in regular contact with my victim, and she could provide me with updates as to what's happening, if there's any additional disclosures, if there are things we need to follow up on. You also are able to understand the impacts of the trauma to that victim, and you have the support of the team, especially, again, your victim advocate. You're also, by having the trauma-informed approach, you build a stronger case. You have all members of your team working together. Teamwork makes the dream work. And your victim is cooperative and working with the team. You're able to identify the issues early. Those who have interaction with your victim, they can tell you about those idiosyncrasies that have developed. They can tell you about those different issues that are going on. And you can also be able to know the expert witnesses that you will utilize based on those issues as they come up. Now, our most important evidence we're going to have, obviously, is the victim statement. That is the crux of your case. That is the evidence that you are able to put forward, and it's your primary evidence to establish the elements of your crime. So when we're interviewing with the victim, we want to make sure that we meet with the victim early. Have your advocate and your investigator present, because there is always the chance that you may need to impeach your own victim, which we will talk about later. But you also want them to know that they have a team standing behind them. You also want to be conscious of that victim if, say, she feels uncomfortable with a certain individual. Maybe she doesn't want to disclose with a male in the room. Maybe there's something about somebody that is a trigger for her, or something that's a preference that she would like to have or wouldn't like to have present in the room. And so you just need to be cognizant of that. Another thing that helps you do is prepare for your case, because if you know that she says, well, for example, I don't want a male in the room when I disclose, then you need to definitely work with her throughout the pretrial process and work with her to let her know, look, there are going to be men in the courtroom when we try this case. And so just knowing that that's another layer of your trial prep. You want to meet at a comfortable place and time. Now, this obviously goes with the caveat that you do need to be accessible to your victim. So if she says, look, I don't get off work until 7 or 8 o'clock, then you need to meet her at 7 or 8 o'clock in order to prepare your case. But typically you want to be able to meet at a place and time that is suitable for her. You don't want to interrogate. Now, I say that to say that does not eliminate the need to confront your victim with inconsistencies and allow her to explain them. But you do not want to interrogate her. And you, again, thoroughly want to explain the process, the criminal justice system, and review her role in that process. And explain the rights of the victim. And also, most importantly, you want to inquire about her safety. Where are you now? What, if any, communication do you still have with the perpetrator? Understanding those family dynamics, if any, that exist. You want to be sure that you're exploring those in the interview. Now, we talked about trauma. And so part of that is going to impact the victim's recall during that interview. She may be able to only remember it in fragmented, in pieces, as she's recalling the assault that occurred to her. Or imagine if it was ongoing abuse, if it was repetitive abuse, how that can kind of come up in a non-linear, disorganized way. She may not be able to tell you a date and a time, but she can surely tell you what happened. And it may include random, non-relevant facts as part of her ability to recall, as part of her ability to tell her story of what happened to her. And all of these things are important for you to understand before you put her on the stand. And also to tell your experts so that when you have them to testify, to explain how the victim is recalling her abuse, that they are able to do that and explain to the jury any of the issues that you may see. Now, we talked a lot about having a victim-centered case, but we do not want a victim-centered trial. You may wonder, what is the difference? So what we want is, we don't want our entire trial to only be based on that victim statement. It's not fair to her. It's not fair that she sits in that witness stand and that is your entire case, and it only hinges on whether or not they believe her. So how do you cure that? It's simple. That statement she gave you, you have to try to corroborate as many details as possible in her statement. Because what you can then do is argue to the jury, look, she told the truth about these 8 other facts, so why would she lie about the assault? And so you're building up that victim's credibility by corroborating as much as you can about what happened to her at the hands of the perpetrator. And so that goes to evidence collection. And every jurisdiction is going to be different on how they have their evidence collection set up. But your best case scenario is going to have a sexual assault response team. Yes, it says utopia. However, I understand the irony that in utopia, there would not be sexual assault cases. But if you were to have a utopic response to sexual assault cases, it would be a SART team, a sexual assault response team. Your sexual assault response team is typically a multidisciplinary, coordinated team that is both victim-centered and response-focused. They're there on the front lines when the report is first made by the victim. The members of your SART are going to be your victim advocates, your law enforcement, your prosecuting attorneys, your SANE nurses, the sexual assault nurses, the crime lab, and your service providers. They all should be readily available when that victim makes the disclosure so that you are able to build the strongest case possible. So what does the SART do once they get called in? Well, there's a system in place in which they alert each other and say that, hey, we've got a case, we all need to respond. They respond in a timely manner. They share the initial case information and determine the evidence collection needs based on that disclosure. They address the special concerns and they reduce the need to duplicate the questions because everybody's in the room at that time and they can all be on the same page as to what evidence needs to be gained from this victim. They also will have an interview with the victim. Of course, it's not 20 people in a room with the victim, but it can be coordinated where there may be, say, one interviewer and a victim or two interviewers and a victim, and everybody else via closed circuit is able to actually observe and take part in this. And it also allows for the immediate collection of medical examination evidence as well as other forensic evidence that can be collected at that time. The benefits to a SART team, it has proven to increase reporting and conviction rates when you have this multidisciplinary team approach. It is improving prosecution rates of sexual assault crimes, and it's reducing incidents of re-traumatizing the victim. Not eliminating, we all know that that can't happen, but the fact that we can reduce it is definitely a benefit. And it also meets the needs of the individual communities in knowing how to respond to their particular population. So what about the other side? Let's say you don't have a SART team yet in place, or your SART team is not up and running. So the other side of the coin. Well, the most important aspect to having a successful sexual assault investigation is going to be early communication with law enforcement, because they're obviously the ones that are getting the reports first a majority of the time. When dealing with law enforcement, you always want to be available for consultation. You want to make sure that the individuals are, the officers and leadership within law enforcement know that you are accessible. Now, prosecutors, I don't know what your mantra is, but this is not a 9-to-5 job. If the call comes through at 10 p.m., if it comes through at 3 a.m., there needs to be a system in place within your office that there are prosecutors accessible to law enforcement no matter the time. You also want to review the files with the detectives as soon as possible. If they don't call you at the time of disclosure, or if they're saying, hey, I just have a case I'd like to run by you, make sure you're accessible and do it as early as possible. The other thing is that you want to be able to have a good rapport with your law enforcement, and that takes time to build. It's not something that happens overnight. And ask them to follow up on the case and different things, a to-do list, if you will. One thing I'm notorious for are my to-do emails, and all of the officers that I work with are well aware that when they do a case review, I am often sending them a checklist to make sure that they follow up on certain aspects that are relevant to the case we discussed. You also want to review the selected charges with a detective. Now, this becomes important for the initial arrest warrants, but as prosecutors, we also know that we have the leverage to change and add charges or delete charges as we deem necessary once the case comes to us and we present it to grand jury. But you do want the officer to be on the same page to know what is out there and what is available to them. Use your lead detective for grand jury if possible. Why? They know the most about the case. It's their case, and they're the best able to articulate what happened in that case to the grand jury. And of course, you want to thoroughly prep them for trial, which we will talk about, and keep them abreast of the status and the disposition of the case. One of the biggest complaints we get from law enforcement communities is that they don't know what happened to that case they put all that work into. So as a courtesy and as a part of the working relationship, you should always tell your officers what ultimately happens with the case. And of course, volunteer to lecture with law enforcement. That helps the rapport building, it helps the relationship building. If you are accessible and you go out and you do trainings on what sexual assault cases look like, what your office's policies are, produce checklists, things that will help them in their investigation. Processing the crime scene. Oftentimes our window to do this is very, very slim. You want to collect and test the evidence, the sheet, the clothes, the blood, whatever may be on scene, you want to be sure and collect that. I actually had a colleague who handled a sexual assault case, and it actually happened in an abandoned apartment. And when they went back to review the crime scene, ironically enough, the victim had disclosed to them that the assault took place on a cardboard box. And lo and behold, when they go back to the crime scene a couple years later, that cardboard box is still there. And they collect it and they test it before trial. And believe it or not, the defendant and the victim's DNA happened to be on that cardboard box. Now that is a rarity. So the primary purpose of when you're collecting evidence is going to be to do it as soon as possible, because we don't always get as lucky as they did in that case. Take lots of photos, especially with cell phones nowadays. It's free. And then we could figure out what we need and what we don't. Always remember there's a crime scene. One of the biggest issues that we have in moving these cases forward is that sometimes where the victim discloses the incident happened, the police never process. And so we don't have those crime scenes of the incident location. Even if it's too late, if the officers have cleared the scene or whatever the situation may be, as you're prepping your case for trial, see if you could get back in and take those photos, because they will be key when you are showing the jury what happened. Because if you think about it nowadays, everything is visual, whether you're TV, whether you're Netflix, whether you're social media, whatever it is, everybody wants to see it. And that also holds true for your jury. So make sure you get your crime scene inside and out, including the minor details, the surrounding areas, because you need to be able to explain who could have seen or heard or who could not have seen or heard if there is that type of defense that you need to combat. Surveillance videos. Were there any surveillance videos in surrounding areas? Even if it wasn't the assault, what about if it was the pathway that the defendant took the victim prior to assaulting her? What if there's a tag that could be read from the surveillance video? These are all little keys and nuggets that help you to prove your case up. Aerial photos. Google Maps is an enormous friend for prosecutors. When we're able to take that aerial shot, not only does it help us to establish venue, but it also helps us to explain a lot of times what occurred during the crime and all those peripheral facts surrounding the actual assault. And map the path and the versions of the facts that the victim gives you. Time the routes. If this is a case where she was transported, go and drive those routes and time it and see how long it is and see if it coincides with the victim. And make sure it matches up with her version of the facts. Your medical experts, learn from them. Be able to be vulnerable to what you don't know, because you have to learn it before you explain it to the jury. You cannot teach what you have not learned. And so make sure that you are learning from your experts, specifically when it comes to your medical evidence. Rape kits are huge. In the cases where we actually have a rape kit done, a majority of the time, it's a negative rape kit. We don't get any DNA matches. And so when you know your medical experts and you've had the conversation with them, you have to be able to explain to the jury why that is still corroboration of the victim's events and what she said happened with the perpetrator. What if you have the DNA of the perpetrator in there? Being able to explain the probability associated with that. And of course, the defense becomes consent and being able to combat that. If it's not the perpetrator's DNA inside of her rape kit, what if any motions in limine may you be able to file? What if any other documentation that you need to do or arguments that need to be made to the jury regarding that? Use of the evidence of a normal exam. A normal exam is what we expect to find in most sexual assault cases. You have to know the hymen. The hymen is the biggest mystery for some reason to our jury. And you have to be able to explain that it's not this sheath of skin. You have to be able to explain what a prepubescent and postpubescent hymen looks like and how an estrogenized hymen therefore is able to absorb a lot more impact and stressors, and why you may not see any type of injuries to the victim's hymen. Be able to advise your law enforcement to swab for other DNA samples. Typically, the perpetrator will not only make contact with the vaginal area of a victim and may touch other parts of her body using his mouth or genitals or any other part, that you may be able to swab and get DNA samples from other parts of the victim's body. Your STD and STI testing, be able to know whether you want it in or want it out, and whether you need to go and get a search warrant for the defendant to see if he also has those same STDs or STIs. You want to look for signs of physical abuse, whether they are acute or remote. Did they happen recent in time to when her allegations are, or were they a long time ago? Is this a chronic situation of abuse? And your medical experts can confirm that. Matching bite marks. There's a whole dental forensics world out there to say whether or not bite marks could match what injuries are seen on the victim to the defendant's or perpetrator's mouth. Pattern bruising. Is the victim stating that prior to the incident she was beat with a belt, a hanger, an object, whatever it may be, and being able to have your medical experts say whether or not that actually corroborates the injuries that were on her body to the object she alleged struck her. And again, just any consistent injuries to the victim's allegations. I want to play a quick video for you on what is happening with rape kits. This video talks about it on the federal level, and it's a really important movement that is happening and that we need to be cognizant of as prosecutors of sexual assault cases.
This law came from a very personal place. I remember walking out of the hospital after my rape kit examination and feeling so alone. The crime scene is your body. It can last up to 7 hours. It's 3 to 7 hours. Mine was 6 hours long. This is why this is a civil rights issue. In what other crime would you be expected to pay for evidence collection? In what other crime would you have to fight to get access to your own police report? I remember fighting the Massachusetts criminal justice system in trying to preserve my rape kit from being destroyed. I had a choice: accept the injustice or rewrite the law. So I rewrote it.
She had the tragic circumstance of having been raped in Massachusetts, and despite the state's 20-year statute of limitations for sexual assault, Amanda has had to return to the same police station every 6 months. She has to relive the crime that was committed against her and hope that her evidence is not destroyed. Fortunately, Amanda didn't give up. She decided this was wrong. She was going to do something about it.
When I heard her story, it's sadly not unlike many other stories that I've heard over the years. It was kind of a no-brainer to say, yes, you're right, we should do something to address this. We need to make sure that the system doesn't re-victimize people who have been through sexual assault.
We wrote a civil rights bill on the federal level and got it passed unanimously in Congress, in the most partisan Congress in history. 399 to 0 in the House and 89 to 0 in the Senate. And the president just signed this into law.
Every 109 seconds, another American becomes a victim of sexual assault. That's every 109 seconds. After all these survivors have endured, the last thing they should have to deal with is a broken system.
We're trying to take this fight into the states, and we're trying to get all 50 state houses to pass this.
It's overwhelming. I witnessed my own civil right be signed into law.
You know, I have 3 daughters, I have 3 granddaughters, and we need to change the culture in this country around sexual assault. It's the most underreported, underprosecuted crime, and we need to make sure that future generations don't have to go through the trauma that Amanda and so many other people have gone through.
Where'd you find that? Right. So you can see how important it is that when we are taking this fight on as prosecutors, how many other issues that are impacting what we do. Now, I don't know what jurisdiction you're from, but I know here in Georgia, we've started to take a statewide effort to go after and start to work up all of our backlog rape cases. And there's a bit of a difference when you're dealing with those types of cases. When you're dealing with the backlog rape kit testing and cold sexual assault cases, there are a lot of other elements that we won't cover necessarily in this training, but there are other dynamics to it that you also need to make sure you're doing. If you have a CODIS hit case, regardless of whether it's an old case, a backlog case, or a current case, make sure you're getting that DNA sample from your perpetrator to confirm the hit. You have to also be cognizant of your statute of limitations issues, and if the presence or the location of the defendant were somehow known, then your time would start to toll. Just be aware of those issues and how they may impact you. Your victim contact. Understand that if you're dealing with a backlog/cold case and you're calling somebody up 20 years later to talk to them about the rape that they endured when they were 19, 20 years old, you have to be able, again, the trauma-informed approach. Know what you are bringing up. Know what you're asking them to do to discuss this thing that happened so long ago and that they're trying to move past. Your witness availability. These are very real concerns. Are your investigators still alive? Are your service providers or therapists or whomever it is that also is a witness to your case, are they available? Do they have recall? Are there other issues that will impact your ability to go forward? And of course, if you have a serial sexual assault or serial sexual rapist, then that's another dynamic. And then you're talking about multiple victim interviews and having to align them with the facts of the case that you are putting up. But that's another matter to go more in depth in other trainings. And there's plenty of great trainings out there. And so if you have those types of cases, I strongly encourage you to pursue those trainings and what to do and the different dynamics of handling those types of cases. So again, we're talking about evidence collection and gathering evidence. You want to make sure that your phones are collected when it has to do with these cases, especially if it's an acquaintance, a family member, somebody who the victim knows. You want to be sure that you're pulling your 911 calls and your CAD reports on all your cases if that's how the call came through. You want to pull the defendant's phone records. When we deal with our human trafficking cases, it's very important that we get those phone dumps because it can show us, were they on Backpage, were they on some type of website where they were trying to locate a prostitute? Is there some other type of data on their phone that helps to corroborate that they were targeting prostitutes? All those different dynamics. Your victim's phone records, again, if it's an acquaintance or it's somebody that they know, has there been any prior conversation, communication, things that help your case out? Cell tower information. So for this information, at least in the state of Georgia, you cannot get that by subpoena. You have to get it by a superior court warrant. You want to collect that because, again, that can help place your crime scene and corroborate your victim in what she is saying. And our golden nugget every time, our gem in the rough, those jail calls. No matter how many times that recording says, these calls are recorded, for some reason, a vast majority of our offenders still love to talk. So make sure you're pulling those and reviewing those. Your electronic evidence, your cell phones. Again, we talked about that, but you want to get the call logs and the text messages, the tablets, anything that has data storage capacity, laptops, computers, whatever it is. Our cell phones obviously are the most obvious because everybody has them all the time. Their social media account, whether it's Facebook, Instagram, Kit, you want to be sure that when you collect that evidence, you're asking for a business record certification. Here in Georgia, that allows us to get the evidence in at trial without having to actually bring in a witness from those different jurisdictions. Snapchat, sometimes they'll get the information, but they're housed out of Canada, and they will not be subject to any of our subpoena power. The peripheral interviews. Yes, this happened to your victim, but there may be other people that also have evidence and information that can help you pull off your case and get that guilty verdict. Talk to the neighbors. Did they hear anything strange? Was there any long-term behavior that they observed? Any eyewitnesses to the incidents that occurred? The family members, did what they observed about the relationship between your perpetrator and your victim? Children. Unfortunately, kids have to witness a lot of these events, or the events leading right up to or right after a sexual assault. If you have a child who witnessed a sexual assault or any of the surrounding facts, make sure you get a forensic interview of that child, because then you can get that evidence in and have an expert to explain why the child would disclose in the way that they have. The unnoticed evidence, make sure you're paying attention to that. Corroborate as much as possible. The events leading up to the assault, it could be something as simple as a food receipt that has a date and time stamp that can help you prove your case. And I say this because it's happened in my cases before. The store receipts, time stamping of the incident. What was on TV when it happened? What were the actions of others? Had the mail just been delivered? Had some other routine event occurred right before or right after that can help you narrow that time frame if your victim is unsure? Also, to corroborate if they are sure that the incident happened within that time frame. The objects that are described at the incident location, the basics, the colors of the curtain, the description of the sheets, the furniture. What did the ceiling look like? What were the magazines that they may have seen, the smells, all of those contextual details that you can then confirm that this victim actually went through this to your jury. And the lack of evidence. I mean, let's be realistic. We are going to have a lack of evidence. There's not one case I've put up where the defense has been able to get up and say, you know what, they got everything. They're always going to find something that we did not get as part of our case. It's our burden. We can't burden shift, and we have to be able to explain why we did not get that evidence in a way that makes sense to the jury. If it's DNA evidence, you then have to have your witnesses testify to why the victim's delayed disclosure would not allow for physical DNA evidence to be collected. It is our burden in every situation and where there was evidence of a crime being committed and we didn't get it. Another important thing is the defendant's prior criminal history. We follow here in Georgia the federal evidence code, and so we have a lot of the same numerical numbering for our code. And so whatever your jurisdiction may have, as far as this, your evidence code, similar transactions, 404B, 413, 414, scrutinize that criminal history. When you get that criminal history, go through, pull out the reports, even if they don't seem directly relevant. If there's a burglary, a criminal trespass, a battery, get into the weeds of it, see what happened, and then maybe contact those victims if you think there's something that may connect the dots, and you may have a prior difficulty to be able to put in, or a prior similar transaction. Recidivist notice. If your perpetrator has a criminal history, use your tools as a prosecutor. File that recidivist, get your certified convictions. What we also want to talk about is the history between the defendant and the victim. Those prior difficulties. That's really where those peripheral interviews come into play. You want to get that evidence from the victim. What history, if any, do you have with this perpetrator? Talk to the family members. How was her relationship with him? Do they say, oh, you know, it wasn't that bad. I mean, he only hit her if she spoke up too loud or things like that. Also, don't put your normalization of things and place that on your witnesses or victims. I can't tell you how many times that I would ask a victim if the perpetrator ever physically abused them, and they would say no. And then you would delve into deeper questions. Well, did he ever put his hands on you? Well, only when I talked back, or only if I wasn't able to do what he asked me to. You can't say that they equate what they've been through to physical abuse, because they may have normalized that contact and that conduct. So make sure you ask the extra questions and delve a little deeper in. Also, pull 911 calls to the incident location. How many times have the police responded? Do they know this couple? Do they know this group? Do they know this pairing? Pull the prior law enforcement reports, and again, the peripheral interviews. And know your victim's history. You don't want any surprises. It's happened to all of us, if you've done this long enough, that you have the victim on the stand and you hear something on cross that completely blows you away because you had no clue. We've had situations where we would put up family members or even the victim themselves who says, yeah, I still know the perpetrator. I'm still in contact with him because he sells us weed, or because of all these other things that you just had no clue was coming. So make sure that you are asking all those delving questions to your victim to know what is happening in her past and since the incident. And then use your tools. Use your rape shield if that's necessary to exclude any evidence of prior sexual conduct of your victim with others. And your motions in limine to make sure that you are narrowing the issues to be tried before the jury to the ones that are important and relevant. Know your victim post-assault. Make sure that you are aware of what you're dealing with since the assault. Does she have any unhealthy coping techniques? Has she been observed by loved ones doing things that are different since the assault and after the assault, which is great corroborating evidence. For example, if she used to, this 29-year-old was fine, home alone, living on her own, independent, and after the assault, now she can't sleep with the lights off and she has to have somebody else in the house and she bought extra locks. That is excellent corroborating evidence if you could get that in. Has she been to therapy? Are there additional disclosures you need to be aware of? Does she have new fears? Is there Stockholm syndrome? Is there something where she feels indebted to her perpetrator and so that may impact your ability to get her testimony? Does she minimize what happened to her? Has she been through so much abuse throughout her life that what this man did or this woman or whomever it is did to her, she minimizes and she doesn't understand the impact of what has happened to her? Are there threats by the defendant or the defendant's family and friends? Is she being intimidated? Is there economic or emotional pressure to drop the charges? Is he the main financial support for the family? And so she deals with it just because she can get by and still feed her family by continuing to be assaulted. Are there immigration issues? This is a very hot topic because we know that there are victims who are often being deported regardless of whether or not they are a victim in a crime. And so is she being promised some type of visa or privilege to stay in the country if she is not a legal resident? And being aware of that. And also know that all those things that we just went through are potential for the defense to turn against you and to say is why your victim is not telling the truth. Now, you may have a victim who's reluctant or recanting. Remember early on, we talked about some of the fears and why a lot of the victims don't come forward. Those are a reality whether or not they are actually involved in the prosecution or not. And so be prepared if you have to, perhaps, to impeach your own witness with a prior statement, inconsistent statement. Be aware of spousal privilege and the parameters in your jurisdiction and when your victim can invoke that and when they cannot. Explore the bias. If they fall back, talk about, well, what has happened since you reported this to the police? Well, we got kicked out of our apartment. And now we're living in our car, and things just so that the jury understands why her version of the facts may be changing now. And let them tell their story. Don't try to beat them up too much on the stand because the reality is they're still the victim. Let them tell their story and then let the evidence tell the truth if you have a victim that's trying to change on the stand. And also be prepared to deal with the victim's response at trial. Understand for a lot of our victims, this is their first time seeing the defendant since the assault happened. And so they may have a lot of different types of responses. It is not unusual. I can tell you that I have had victims in assault cases get on the stand and they're laughing and smiling or giggling at the defendant. And you have to be able to have your experts in place to be able to explain this kind of bizarre behavior when you're putting up these types of trials. Make sure you're showing them the exhibits prior to trial, review statements with them. This is a toss-up. This can be controversial. And so you have to be able to judge the merits of your case and see what's best because you don't want it to appear like you have coached them and given them all their prior statements. But at the same time, if there are certain things you need to refresh your recollection on, you need to be able to do that. So always make sure you're doing that balance test in your case preparation. You have to understand the discrepancies. So from what they tell you 2 years after the assault, as sometimes it is in our jurisdiction, or even longer, to when they actually told the officers 2 hours after the assault, and being able to line those things up. And sometimes, yes, you have the amnesia on the stand and all of a sudden they don't remember anything because of all those dynamics we previously talked about, and being able to refresh their recollection when they're on the stand. Always prepare them for the cross in a non-offensive way. So there may be some really hurtful things that are going to come out on cross, and you know it, and you have to make her aware of it. So make sure that you are letting her know in a non-offensive way So one way to do this is instead of, just coming out right and saying it, saying, well, look, the defense's job is trying to prove that what you're saying is a lie. So if the defense said X, Y, and Z, what would your response be to that? And just prefacing it and making sure that you're very thorough in that preparation. And that goes for any of your witnesses. Now, for the lay witnesses, you want to make sure you explore their relationship change, if any, with the defendant and or the victim. See if that has impacted anything that they have to say that they originally told law enforcement to the time that you're actually at trial. Make sure that they are able to review statements and, again, understand the discrepancies and know the biases, even with your lay witnesses. Law enforcement, review the evidence you intend to introduce with them. Go over the questions, make sure they're familiar with the case file, because we all know that our law enforcement officers are overworked. They have so many of these cases, and the facts can get confusing from one to the next. So make sure that they're well versed on your case that's going to trial. At least the victim, the defendant, and the witnesses' names involved. And of course, when they're on the stand, they can refresh their recollection with the actual report. Explore the 3,000-mile view. So if you have a special victims unit detective, somebody who specializes in these types of cases, get them to talk about that. Let the jury know that this is not an isolated incident. So for example, I may ask my law enforcement witness, how many sexual assault cases have you handled? I've handled hundreds. How many has your unit handled? Oh, I can't even begin to get a number. Well, let's talk about per year. On average, how many do you get? Well, we have 4 detectives, we have 6 detectives, whatever. We have 2 detectives, and we get an average of 5 each per month. And then you do the math with them, and you let the light bulb go off for the jury to say that this is not an isolated incident, this is an epidemic. And so you have that argument as you pursue your case. Qualify your law enforcement officers as experts in sexual assault investigations so you can explore the hypothetical. Now beware, the defense, of course, will poke holes in your case, especially the investigation, and will target your officer if you go into how they've done all this work and they've handled all these cases. The defense's position is always, well, if you've handled so many, why didn't you do X, Y, and Z in this case? So prepare your law enforcement witnesses for that type of cross-examination. Your experts, medical, psychological, your lay experts, be able to have them to explain the elements of your case, the existence or lack of physical evidence. Psychologically, you have to get your experts in to talk about, well, why does she stay with him if he assaults her, if he beats her, or these things? To talk about if she has a flat affect, if she's describing a brutal rape, and she's talking about it like I'm talking now. Be able to have an expert to talk about why that may be and why that's still consistent with her having gone through that. And also to explain the methods of coping with sexual abuse, those idiosyncrasies, the laughing, the smiling, if there's other elements that you need to describe of what she has done post-assault and how that's consistent with a sexual assault abuse victim. And the lay experts, don't be weary, if you will, of qualifying your lay witnesses as experts, especially victims. In a prostitution case, for example, you may need to ask hypotheticals of your victim who was a prostituted person that categorized issues that happened in the life and why what her response was or what she did coincides with a sexual assault victim given the circumstances of being in the life of prostitution. You can do that. It's anything outside the ken of the average juror. Now, the common defenses. Be prepared to defeat those common defenses. Know your case, know what they're going to throw at you. Is it going to be an issue of consent? Is it going to be an issue of mistaken identity, like the photo here with the soccer player from Brazil, and they made fun and put the picture of Obama on his equipment? And it's just in jest, obviously, but I'm just saying these are types of things. These are real defenses that we hear in these cases. The scorned or jealous lover, she's just trying to get back at him. There was never an assault. The prior false allegations of, she said that all these people have raped her, and being prepared with your case law and your motions to combat that. And character witnesses. I think that some of the most irrelevant character witnesses come up in your sexual abuse cases because usually these are people that know them from the community. And quite honestly, if you want to get to the quick of it, you simply say, have you ever slept with them? Because what do you know about what goes on in their bedroom or in the secrecy of their home? And how can you sit here and say and give an opinion as to their character when you have no idea who they are in these circumstances? So things to think about as you're dealing with your sexual assault case. And the ultimate thing that you need to do to combat any defense the defense may put up is, what does this cost her? This is a cost-benefit analysis. What has she gained by coming forward and describing in excruciating detail the sexual assault that took place. And usually I'll do a PowerPoint, and in it I'll have one succinct chart that highlights all of the reasons why she would not be making this up. Because it just doesn't make sense for a woman to put themselves through this process unless it really happened. And our job as prosecutors is obviously to evaluate our cases and make sure we have a good case prior to putting it up for trial. One other thing is you want to make sure that you are charging all the proper charges. They don't exist in a silo, sexual assault cases. There are other issues that happen, whether it be drug charges, burglary, terroristic threats, gang-related offenses, domestic violence charges, aggravated assault, human trafficking, whatever it is that goes along with the sexual assault. Make sure that your indictment is accurate and the jury gets the full picture of what's going on. I want to show you a video on the impact of sexual assault. This was actually a poem done by a student regarding what girls go through as they grow older. So we'll play that now.
From the age of we were told that if boys pulled our hair or poked us with pencils, it meant that they liked us. But we didn't like it that much. We were 13 years old when we would walk down the street and had men look from our feet to our face, and we'd listen as they completely replaced our identity from human to object. As they said cringeworthy things to us, we wanted to run. We were frozen in place but continued walking fast-paced, turning on whatever sidewalk was closest just to get away, even if it didn't lead us in the way that we were originally going. Because Mama always said, if you see a strange man following you, you go to the other side of the street. And remember, if they ever grab you, scream. And that's something we had to learn at the age of 13 because we are just young fiends. We were spanked by the boys at our school, but it was cool because it just meant we had nice bodies. And they rated our bodies on a scale from 1 to 10. And if you were a 10, you would learn to spend your days hearing whistles, purring, and damn girl. Because if you were a damn girl, then that meant you weren't a damn girl at all. You were just a toy labeled, do whatever you want to me, even though I don't agree. And we had to watch what we wore because if too much shoulder was showing, we had to change our clothing because it distracted the boys from their learning. So the only thing that we were learning were tips and tricks to tie up our shirt so that it didn't hang too low, because that would show the guys that we wanted. Because wearing shorts and tank tops meant that we were flaunting it. So when we were 16, we screamed because the men that followed us on the sidewalks finally caught up to us. We quietly said, please don't touch us there. We know we're asking for it by wearing these heels, but we just feel so uncomfortable, so stop. But that meant go. We said no, but that meant yes, so they grabbed us and unzipped our dress. They threw us down where our dignity sank lower than the ground. They hovered over us and we pleaded for them to stop. They got on top, and you don't need to know the rest because we are some of the 68% of victims that will never tell a soul, so we'll just grab our dresses and go home, take a few showers, and try to get some sleep. In the morning, we will pick out the outfit that is most discreet because we want to make sure that no other man from the street thinks we look sweet enough to want to taste. We want to make sure we are as covered as possible so that our identities are not replaced with walking candy. And we will sit at the back of class where nobody will ask how our weekend was because if they ask, we might just burst into tears. And we will live in fear. We will run home so that we will never see the same men again that wait for us to be alone. We went from little boys poking us to men provoking us. We went from little boys pulling our ponytails to watching the trail of tears fall down our pillow every night because we knew once we fell asleep we would see the men in our dreams, nightmares that caught up to us on the sidewalk that night and left us bare. We went from playing with our toys to being toys ourselves. So boys will be boys, and us women will never tell. Thank you.
Unfortunately, that is the reality with sexual assault here, that the vast majority of victims of sexual assault will never say a word. So if you have the opportunity to stand up for one of these women, girls, men, then be sure that you do it to the best of your ability. The organization RAINN, R-A-I-N-N, made a great infographic to show that out of every 1,000 rapes, 994 perpetrators will walk free. And the breakdown that 310 are reported to police, 57 report lead to an arrest, 11 cases get referred to prosecution, 7 cases lead to a felony conviction, and 6 will be incarcerated. The odds are not in our favor. But when you look at the impact it has on survivors of sexual assault, Jean McAvney said, "You can recognize survivors of abuse by their courage. When silence is so very inviting, they step forward and share their truth so others know they aren't alone." Being silent is the easy thing to do in a sexual assault case. And if they have the courage to speak up, to stand up not only for them, but countless others that remain silent, we as prosecutors have to take it seriously. I will leave you with the same quote I leave to every jury when I try my cases. The world is not dangerous because of those who do harm, but because of those who look at it without doing anything. As prosecutors, we have to do something. The cases won't always be easy. The challenges won't always be surmountable, but we always have to stand up for those that are brave enough to stand up. Thank you.